One, welcome to this webinar. So today we have lawyer Arianna Esfathiou. Sorry if I'm mispronouncing your last name. It's really hard. It's an immigration attorney with David Hirson and Partners. So lawyer Arianna specializes in self-petitions for high-skilled individuals, but also uh, regularly she takes business and investment-based immigration matters. So David Hirson and Partners issue leading full-service immigration firms with offices in Costa Mesa, California, and Seattle, Washington. And today, lawyer Arianna, sorry, is going to present EB2 National Interest Waiver Pathway to Permanent Residence. So, lawyer Arianna, the floor is yours. Thanks for your
Awesome.
presentation.
Thank you so much, and thanks everybody for joining today. I do have a PowerPoint that I can share my screen so that you guys can see it. I won't be able to see you guys then, but it looks like most people have their cameras off anyway. And I know that usually the format is to have me go through my spiel kind of, and then do questions and answers at the end. So if you guys have a question, try and wait till the end because I might cover it anyway, and someone else might have the same question as well. And I did receive some of your questions that you submitted with your registration, but I'll kind of go through a couple of those. I don't want to focus too much on those until I know that the person who asked is actually here, right? So we can work on that towards the end of the presentation. Let me go ahead and share my screen. Okay. So I really wanted to do something a little bit different today. I know that many of you have probably been to more than one of these webinars with my colleagues, and there's a lot out there online about the NIW. And so what I wanted to offer today is something that challenges you to think about all of this in a different way. And I think it may be new to you guys. I've put this together based on all of the consultations that I do with potential clients. Many of them are Indian nationals and have the same kind of specific concerns with the EB2 category. And so I have put this together to kind of address misunderstandings that I've seen over and over again, or to offer you some insight that I think gives people kind of an aha moment when they start to put more pieces together and understand kind of more comprehensively what it is that we're doing when we actually put together a successful petition for a national interest waiver. So please, if it seems a little bit different from what you've seen before, that is on purpose, and I'm totally happy to discuss at the end questions that you still have about it. But I think it's going to be new for most of you, and I think it's going to be really valuable for everybody. Okay, so the first thing that I wanted to talk about is what the NIW is not. It is not the same as the EB1A petition, and that's kind of the most important thing that I think helps you just start thinking of the NIW in this new perspective. I think there are so many similarities between these two different classifications that it's really easy to confuse them or conflate them, or to think of the NIW as simply an easier version of the EB1A. But in fact, legally, they're quite different. So we're going to talk about exactly what an NIW is in a few minutes. But please just remember right from the outset, the EB1A is a self-petition, so they have that in common. The EB1A is for people who have extraordinary ability in their field. And the remaining legal requirements are similar to those for the NIW, but it's a different case law that provides authority here. So different specific language in case laws, different regulatory language. And it's helpful to kind of compare these two because you can understand why you may not need kind of so much a claim in the NIW that you would need for the EB1A. But I really want to make it clear that that's kind of the limit to how useful it is to compare these two. They are not the same. The perspective that USCIS has on these petitions is not the same at all. Okay, and you know, in that same vein, the national interest waiver is not simply a checklist of criteria. So a lot of the questions that I hear and see over and over is about this list of national interest waiver criteria. Does this thing that I've done in my academic or professional history qualify for this list of criteria? That's a very small piece of the NIW process, and I think it's the most kind of easy one to research online, and so it tends to be something that people think about a lot when they're deciding whether they could be eligible for this. But it is so far from the most important thing here that I really want to challenge you guys to kind of step away from that idea mentally, so that today we can focus on some of the other elements that are arguably much more important to a successful NIW petition. And unfortunately, they're a lot harder to kind of wrap your head around, but that's what makes these cases challenging. And so today, we're not going to talk so much about the criteria. We can if you have questions at the end, but really my point is that it's not worth all of this time today. There are other pieces of this petition that are worth more of our energy and more of our time and our attention. Why am I not able to? There we go. Okay. So what the national interest waiver is. These are the things that I find to be more important when I'm deciding whether someone is qualifying at all for this classification, and also when I'm putting together my actual petition for my clients. So that includes things like assembling all of the evidence and documents that my client has shared with me, but it also has a lot to do with how I apply the law and use case law from other successful petitions, how I explain what's going on with this person and their goals, and really just how you tie everything together in a way that a lay person will understand no matter what the industry is. So remember, when we're talking about a national interest waiver petition, this is going to a government employee who works for USCIS. They're not always lawyers. They are, you know, trained in adjudicating immigration applications. So they're not trained usually in the specifics of the industry that petitioner is talking about. So from the get-go, we have to remember that it's really important that any old person can pick up this petition and understand what our argument is and understand what that self-petitioner does. So what the national interest waiver is, it's a cohesive case theory. That means that from the outset, we're figuring out why you qualify for the national interest waiver, and we're really tailoring everything else about the petition to make that case theory emerge in a way that is clear and compelling. It's a story about you, the self-petitioner, and your trajectory. So what you've done and where you're going. In a way, again, we use the word story because it has to be something that compels and convinces the officer that's reading it, even if they don't really know anything about your industry or your work other than what you're telling them. It is a flowchart. That's every law student's favorite thing in the whole world is a flowchart. So I have included one here on my next slide. We'll go through it. And as you will see, the focus of the adjudicator on this petition looks at your past, it looks at your present, and it looks at your future. So as we talked about, let's shed the idea that this is all about a list of criteria. Instead, these are the ideas that we're moving forward with today. A little more conceptual, a little bit less black and white, and a lot of people have trouble with that. We love when things are easy and they're check off the boxes, but that's simply not the reality of what these cases are when you're trying to get them approved. Okay, so here's my flow chart. As I said, USCIS will be considering kind of 3 big phases of your career. Things that you've already done, things that you're doing right now or kind of capable of doing, and then the benefits that you could potentially provide to the United States if you get a green card. So remember, the national interest waiver is, at its core, it's an exchange. It's a mutually benefit exchange where you get a green card and the US population and country gets the benefit of all of the amazing things that you do in your field. And so the way that they kind of suss out if you're someone that can be beneficial here is by looking at all of these 3 things. They'll look first at your past achievements. So this is kind of the threshold issue. Am I going to qualify for this kind of at a basic level? This is where we see our list of criteria. So I think there are 6 different criteria, and you have to meet 3 of them in order to qualify as an individual of exceptional ability. But you can also qualify, I think I have a slide. Yeah, okay. So this is the past achievement, what you've already accomplished academically and professionally, which in theory is reflected in those 6 criteria. That list of criteria is much more flexible than people realize. One of the criterion actually is comparable evidence, right? So the idea in having that kind of open-ended criterion is that your industry might have different benchmarks for exhibiting success and excellence. And so instead of having a really specific list of things that you have to show for the national interest waiver, USCIS kind of says, okay, you present us with what you think is important that you've done and explain why that's important in your field, and we'll consider all of these things. One of my favorite, that's a really nerdy thing to say, but one of my favorite parts of the national interest waiver is that you actually don't even need to do any of that if you have a master's degree or higher. It's something that people just miss entirely, and it can be really helpful for people that are starting out in their career, and so they've got a strong start, but maybe they're pretty young, or maybe they've changed careers, and so they might not have tons of history of accomplishments already in their industry. So basically, USCIS says you either need to show exceptional ability, and here's all the ways that you can do that, or instead, you can show that you've got a master's degree. So if you've got a master's degree or higher, you're good. You do not even need any of the 3 criteria or anything else. That doesn't mean we wouldn't argue that, because we want to make this like a strong case and hit them with everything we've got. But when you're thinking about whether you might be, whether you might qualify, just remember, master's degree, and you should be good. Okay, so that's where they end their analysis of your past, the things that you've already done. Again, we're not even going to go into the specific criteria, but a lot of their considerations are like, how long have you worked in this industry? What kinds of important things have you done, in your previous positions? Do you have a bachelor's degree in your exact industry? Things like that. So all things that you want to have figured out already, that you'll have already wanted to have accomplished and have it all laid out on your CV. But then the government's perspective changes a little bit. And this is really important because it is an exchange, right? And so ultimately, the government wants the benefit of whatever it is that you do. And in the stage 2, where they're looking at your present position, they're assessing the likelihood that you're actually going to be able to do whatever it is that you're saying you're so good at. Okay, so a business plan is one way of illustrating your kind of thought process and what you're going to need to do to further your cause in the United States if you're starting a business. If you're not starting a business, having a job offer is another great way of showing that you're immediately able to enter the workforce and continue your work. But there are a lot of other things that we can leverage in your petition to show that you're going to be able to continue your work in the United States. Things like your connections, in a professional network, or people that you are still connected with, let's say from the university where you did your master's degree, your language skills in English, kind of ideas that you have that may not be a fully fleshed out business plan, but that will show the government that you know the market that you're working in and you know what's needed to participate in that market. So I'll give you an example here of how this can change depending on what it is that the applicant is doing. For example, I've had many clients who specialize in something that is like tech related, or even like legal, people that are attorneys in other countries, they specialize in business law. And what they want to do with their expertise in the United States is open their own consulting firm. That's pretty straightforward. That's a really easy business plan to come up with. You buy your laptop and maybe you rent an office space and you think about how you're going to market your services and where you're going to get your clients. That's probably almost enough to show the government that you're going to be able to do that specific work. It's going to be harder for someone who is a researcher or kind of needs a physical specialized lab or something like that to actually be able to do their work. So in that case, you really do need to show that you've, probably identified some places at the very least that you would like to apply for work. Universities or medical centers if you work in the medical field, things like that. Because obviously it's going to be hard for the US government to believe that you'll be able to continue your medical research from your home office. Like that's not really realistic. So at this stage, they look at your current position. Are you going to be able to advance your endeavor? So continue working in your field and actually help these benefits materialize for the US government in exchange for getting a green card. And then finally, after they look at you and your past achievements and your present position, this is where they start to consider the national importance involved in what you do. I've had a lot of consults come to me already pretty familiar with the parameters that were laid out in the this case that went through the Administrative Appeals Office. And so there are many factors that are very specific that go into this analysis. And I want to say right up front, there are very few industries that are not nationally important. We can make a lot of different arguments that are compelling about a lot of different fields, whether those arguments are, they offer economic benefits or cultural benefits if this is in the arts, or there's, employment creation for more people. There is increased U.S. competitiveness in an industry where the U.S. hasn't historically been a leader. All of those things and many more can be part of our argument that this does involve national importance. And it's really important to work with someone who can think about a variety of different benefits, because if you don't have one like really obvious benefit, like you're gonna cure cancer, then it is a matter of putting together many different puzzle pieces so that the cumulative effect is that your work is obviously going to have an impact on our country. I know everybody wanted to talk about the 3-day approval that I recently had for one of my Indian clients who works in tech. So I figured we could go through and talk about kind of how we argued their case using these big picture ideas. So this is someone who is still relatively young, but has been very successful. They did a master's degree immediately after their bachelor's. So they did have that master's, and that was, qualified them immediately. But then we also talked a lot about their participation in projects that they'd worked on with previous employers and their current employer, student awards that they had won, and some some publications, though not anything at the level that most people consider for like an EB1A application. They had published, I think, 2 things, and they had reviewed like 2 more peer-reviewed articles. So that was it. We had some really solid letters of recommendation to discuss how important a player they were in their industry roles, but really we relied on that master's degree. So with this person's present position, they have a really great job at a big company where they would like to stay, doing what they want to do and kind of increasingly specializing in what they're passionate about. So their plan for the moment is to just stay put and continue at their company. So we explained in a personal statement that that is the plan right now, but we also discussed the fact that it was going to be important for them to be able to pick which companies to work for as more companies become involved in this specialized tech area. And so they're not wanting to be limited to just one company, and really in order to give the US the full benefit of their skills, they have to be able to collaborate with whoever is doing kind of the most impactful work at the time. But we didn't have a business plan. We had their existing job offer, and we created this statement that just explained all of this plan, as well as like why they were thinking that way and their knowledge of things like layoffs in the tech world that make it a little bit scary right now to hinge everything on your role at one of these companies that has been cutting a lot of people this past year. And that worked, right? The US government understood that this is a person who, even if it's not at this current job forever, this is a person that's going to only kind of increase their impact through future employment, and can only help more people if they decide ultimately to work as a private consultant for many different clients. And then, of course, tech fields are pretty straightforward when we come down to national importance, because there are just so many different ways that tech advances can be used. So we talked about, in this person's case, I'm not going to share their exact specialization, but it is something that has kind of like equitable considerations that can really increase accessibility to services for a lot of people that are lacking accessibility for a lot of different reasons. So we talked about all of those different possibilities. Some of these things the self-petitioner has never done yet, but the petitioner understands and can accomplish the tech creation and implementation that could be used for any of those. But we really did take this approach of putting in tons of different puzzle pieces, none of which were like already accomplished by the petitioner, but just to illustrate all of the potential in this field. So I'll also pause here when we're talking about future benefit. This is kind of where USCIS also wants to consider the balance of everything that we have articulated about the person's expertise, and decide that on balance, it makes sense to allow you to waive the labor certification process. So this is kind of a more subtle, challenging piece, especially for people from countries where there's a lot of competition, because there are so many highly skilled people that can take the the perm process route with an employer sponsor. So we also have to articulate here why, considering everything this person has already done, considering what they're going to do in the future, why we shouldn't just require them to go through the labor certification process, which exists for a reason, right? And that can depend specifically on the industry, but often what we base this argument on is kind of some urgent needs in the country right now. So in number 3, when we're talking about future benefits, we're not really only talking about the person's industry. We're talking also about the state of the union in the US. Like, do we have documented problems that this person's work is going to address? If so, that right there is why this person shouldn't be forced to go through the lengthy labor certification process that we all know and love, right? So we talk about the industry and the country and have to come down, you know, in a convincing and organized way that, considering everything we've discussed, it's still in the interest of the United States to bypass that whole labor certification process to get this person here and working. Okay, so, ooh, this is so not centered. I hate that. Sorry, everyone. We have talked a little bit about this classification being more flexible than I think people realize. So in addition to the fact that the criteria are pretty open-ended here and that you may not even have to deal with the criteria at all, there are a couple of other subtle areas that I want you guys to understand you have a lot of control over and your lawyer has a lot of control over. We decide how to define ourselves and our areas of specialty. Okay, so if we think back to what I was saying about creating a cohesive theory and your whole story that has no holes in it, we decide how we're going to define our experience such that that story makes sense. Okay, I had this really awesome consult once with someone where I was not familiar with his field at all. And hold on, guys, I'm just going to wrap up with the PowerPoint, and then we'll move on to question and answer. But this really awesome consultation where I was not familiar with his field at all. It was something really, I don't know, techie. And I was asking him how his past experience and his degrees related to what he was doing now and would do in the future. And we spent the entire consultation with this ongoing metaphor where we used cooking, right? So he says that his degrees, if he were a cook, his degree would be like a basic, basic culinary tactics of how to chop and dice and make the basic foods and everything. But that his experience before was in a Chinese food kitchen, and his experience today is in an Italian kitchen. And what he really wants to do is open, an Indian restaurant or whatever it is. And so using food, that's how I urged him to decide, okay, are you a classically trained cook then? Is that your specialty? Are you a Chinese food cook? Are you an Italian food cook? Or are you an Indian food cook? And in that way, you can see why it matters how we define ourselves. If we just called this applicant a cook, then suddenly he can use all of that experience and it all works together. Sometimes our instinct is to define ourselves in a really specialized way because we know that what we're doing is specialized and is rare that people know how to do that, but it might not be the best way of describing you because that might really limit all of the evidence and context that you can use in your story. We also know how excellence is demonstrated in our own field. So someone who's in academia, of course, you expect that their publications and citations are going to be demonstrative of their excellence. But if you're someone who is in, antique car restoration, you're the one that knows what the big car shows are. You're the one that understands how competitive it is to be shown at those shows, or kind of the big companies that might want to work with you and sponsor you and things like that. Sometimes you're the only one in the room that understands those considerations. And to the third point here, that's all kind of the same thing. Like, you're the one that understands what it means to be successful in your area. And it might not be what USCIS has thrown out there in that list of criteria, and it might not be what the lawyer is familiar with. So all of these things come together to form the strategy and how you're going to tackle all of these requirements in one cohesive story. Again, there's no specific criteria that is required in every case. some of those criteria make no sense for many industries, and it would be impossible and pointless to do those things in your industry. And there are no numerical minimums as far as how long you've been working, and no other hard and fast rules. So we really do have a big say in the way that we think about what we've done and what we're doing, and the way that we translate all of that into our petition itself. Okay, so again, I think it's really important to remember those things when you're working with an immigration lawyer. You're the expert on you and your decisions and your career advancement and what it is that you want to do and what's possible for you. And you're probably the expert in your industry, as between you and your lawyer. So you can have a huge impact on convincing a lawyer to take your case or helping the lawyer come up with a strategy when you think about yourself in a much more flexible way, as we've discussed. The lawyer, it's our job to be experts on the law. It's our job to be experts in the strategy around the process. But really, neither of us can do this without participation from the other. Okay, and now probably what everybody has heard a bunch of times and probably still wants to talk about, because it's so important here, the special considerations for Indian nationals. I'm just going to throw out these 4 things, and then I know there are a bunch of questions that came in already that involve these, but is there a benefit to an NIW versus the PERM process, even though they're both EB2 classifications, even though the wait time is going to be still really long no matter what you choose? Yes, there's always going to be a benefit to a classification where you can be a self-petitioner. So just think about the fact that you would own your national interest waiver petition. So none of your eligibility for your green card is dependent on your current job or having a job offer from the sponsoring company or whatever that specific situation is. You have so much more control over your own professional decisions when you have a self-petition and you realize that you don't have to stay connected to any particular employer. The NIW can also be part of a good long-term strategy. If you are an Indian national and you figure you do the NIW, you're going to wait about a decade for your priority date to be current. But you can do the NIW. If you do it successfully, you get your priority date and then continue working on your profile so that in another 5 years maybe you can apply for the EB1A. And once you get approved for the EB1A, guess what? You've got a 5-year-old priority date. You just cut your wait time basically in half. So that's the long-term strategy here involving the NIW. There's also short-term benefits for people, like you can continue to extend your H-1B, your spouse can get an H-4 EAD when you have an I-140 approval. So that's true of every I-140, but the NIW is pretty obtainable for people. And so that's why it's important to think about those here. That could be your easiest route to getting an approved I-140. And then just a reminder, once you have an approved I-140, it's not going anywhere, right? So most people, of course, have been here for a long time. They want to raise their families here. They don't want to leave the US, but you could easily go work for a few years in another country, or go back to India for a while if you're from India and there's work for you there. And then your I-140 isn't going anywhere. You can just consular process once your priority date is current and come back to the United States as a green card holder without worrying about any of the maintenance of status, travel abilities, and work authorization issues that you have to worry about when you are kind of transitioning between a non-immigrant status and a green card. So that's what I had for my general presentation. I'll stop sharing and we can get into the questions. Angel, how are we doing on time?
We're doing perfect. So I'm going to provide a quick summary of your presentation. Thank you so much. Your presentation was amazing. From me, I learned a lot of new things, and I hope that the audience learned pretty good things. Well, today's presentation presented by lawyer Arianna was about the EB2 national interest waiver permanent resident card. So she presented to explain the differences and similarities between the national interest waiver and EB1A. So there are some commonalities, but also there are some differences. And for me, the big point is that national interest waiver it's kind of like more flexible and an easier option to pursue. You need to build your case. Basically, you need to create your own flowchart. You need to connect all your past achievements, both academically and professionally, uh, kind of like tied with your present position, and build like a good plan for the future. And basically present your case to the U.S. government and explain why the work that you are doing is of the interest of the government. So you can have like an open door to continue doing your work here. Um, Lawyer Arianna also explained about the flexibility and strategies. And this is a really great piece of advice. Work with a good lawyer to build like a good team. I mean, you are the expert in your field, but a good lawyer is the expert in theirs. So I think that's my brief summary. And we are gonna open the floor for questions and answers. So give me 1 second, please. Oh no, before that, I'm going to hand it back to Dr. Aditi Paul. So she wants to share important information with us. So please, Dr. Paul.
Oh, thank you so much, Angel and Ariana. Ariana, you were so right when you said that you're going to provide a different perspective toward EB2 and IW. You just went toward like the tactical side, the strategic side of EB2 and IW, not just giving us clarifications of the criteria, but also having that eagle eye vision that, okay, what is it that you are aiming for? What is it that you need to keep in mind? Not just throw a list of accomplishments at your lawyer and hope that they find a story. So you need to tell that story for yourself. So thank you so much for that. For folks who are here, really quickly, we have 3 events coming up, and I do want to share what those events are. On October 7th, we have an EB1A panel for founders. Everything is an option when you're an immigrant. Nothing is not an option. So please do not shut yourself off thinking that I'm only going to go for EB2 NIW or I'm only going to go for EB1. Learn about everything and then take the one that works for you. So we have EB1A for founders on October 7th. We have another EB1A immigration seminar for general folks on October 14th with Fraser Greer. He is an Irish immigration lawyer. And on October 21st, we have an event exclusively for international students about job search and interview cinching strategies. So if you want to stay in the loop, please join the Slack community channel that was sent out to you in the email. And I'm going to let Angel take it over and go to Q&A round. Thanks so much, Ariana and Angel again.
Oh, thanks, Dr. Paul. So right now we are gonna open the floor for Q&A. So I'm gonna be calling the names that I saw that they raised their hand at first. So I'm gonna start with Roboman. I think that's your nickname probably, but
Yeah.
please, this is, oh, sorry, before open the floor for Q&A, please limit your questions to one so we can have more people asking questions, please. So please go ahead.
Yeah, so thanks for this wonderful seminar. I just had a question regarding the similar thing as EB2 from an employer and EB2 by yourself. So I'm not extremely clear about the process. So I'm imagining that in a hypothetical scenario, if an employer applies for EB2 and you separately also apply for EB2 NIW and both get approved for I-140, so does this give, and also I understand it gives the ability to renew H-1B visa for 3-year increments. So if we have to leave the company and that had got the I-140 approved, is it possible to shift the I-140 to the EB2 NIW and change employers?
Yes, yes. So exactly. That's why there is a benefit to doing kind of multiple strategies here. because you can use the priority date from your perm-based I-140, right? And you can get whatever benefits based on that I-140. But then once you have your NIW I-140 approved, suddenly none of those benefits are contingent on your existing employer, because you do basically switch over to the I-140 that is a
So
self-petition.
according to USIS, you technically have two I-140s, or it recognizes your EB2 and NIW I-140?
No, so you do have two.
Okay.
They're both I-140s are in the same EB2 category, but there is a different kind of sub-classification. And so when you move forward with your green card application in the future, you'll use the I-140 in the NIW category. And in the meantime, if you were to, end your employment with your employer, you would still use that receipt number for the NIW I-140.
So the new employer gets to use my NIW I-40, right?
So you don't need a new employer. The whole point is like you have an I-140 that no one else has anything to do with.
Yeah.
Your employer doesn't even need to know you have one.
Awesome. Thank you.
Yeah,
Okay.
thanks.
Next one, Privant Kumar.
Yep, thanks, Arianna, for the presentation. I think so. My question got already answered regarding the self-petition and the employer-based EB2. So I have another question. So you mentioned that we can actually also leave if we have an approved I-140, we can leave the country and also apply from green card from there. So is it like a time that I already have my approved I-140, and if I take a job outside, is it there's a time I can only stay for 3-4 years, or is it there is no time foundation there?
So there's no time kind of requirement or limit, but I assume you're talking about having an approved NIW I-140, right? Like you wouldn't want to.
Correct. No, so I have an approved I-140 from my employer, but I understood from the previous question that I can apply for an NIW. So if I have an EB2 NIW approved, then if I move outside, is it a time foundation on how much I can stay outside and apply for my green card later?
No, because you're going to be doing the whole residence process based on the NIW I-140. So you own that. Like you're totally in control of that. They've approved it for you. What you want to be cognizant of, and this is not just if you decide to leave the country, but you are expected to continue working in your field, right? You do have to comply with your offered benefit. But what I want to make clear is for people who it's going to be impossible for them to maintain lawful status throughout the wait for your priority date to become current and all of that, that's okay. You can leave and get your green card via the consular process instead of just feeling like you have to stay in the United States for the whole decade or however long it ends up being, and maintain your status that whole time. You don't have to do that. If you have something comfortable waiting for you somewhere else, you can definitely go and then just initiate the immigrant visa process based on that NIW approval when your priority date is current.
Oh, sure. That's awesome. Yeah, no, thanks. I think so the previous question answered my between the self-petition and the NIW and this one. Yeah, thanks, Arianna. Thanks for the explanation. Yeah.
Perfect. Thank you.
Okay, next question, Srini.
Hey, hi, thanks for arranging this. So I worked as international, I'm a manager in India way back last year, and I moved to USA as a developer. So now my current company is doing my perm application. It's is there a tweak which we can do on the current perm application and enter this NIW? Or that is my first question. And the second question is, if I moved back to my old company, which I worked as a manager, and can I enter EB1Q as I have international experience? So as a manager.
So your qualifications for any of these self-petitions would depend on exactly what you've done. And again, have you shown that you're in kind of one dedicated field that you have advanced to become an expert in? So I would have to see your whole CV and everything But there's no reason that you would not be able to qualify in that field. Like, these are meant to apply to everybody without respect to your industry. It's just a matter of showing within your industry, have you shown that you have exceptional ability? And then, I'm sorry, there was a second question in there that I wasn't sure that I got. So about moving your employer, changing employers?
Yeah. So changing the employer to the whole company. So that my old employer is present in US as well. So if I move back to my old employer, can I apply in EB1 as an international manager category?
So we can talk about that if you wanted to do a consult someday, but I don't want to get into that classification today,
Right.
where we're supposed to be talking about the EB2 national interest waiver. But
Okay.
yeah, again, I think these questions are all things that come down to where you've worked, what these companies are, what you've done there. It's kind of impossible to answer them with such limited information. But you'll have my contact information. Anybody that wants a full consultation, giving me kind of their full CVs, we can definitely do that. My firm offers complimentary telephonic consultations, and it's a lot more valuable for your targeted questions if you can send me your stuff beforehand so I can look it over.
Yeah, thank you very much.
Thanks.
Okay, next question. It's Majwari Gobi.
Yes, thank you. Thanks, Arianna. My question is, I have an EB2 I-140 already approved. It's with a past employer, and now my current employer is interested in pursuing EB2 national interest waiver. So if I pursue with my current employer, will I still have the same flexibility as I do a self-petition?
You never, right? I mean, you own a self-petition. If you have someone sponsoring you, they will always have a stake in that immigration case. So if you can qualify on your own without the sponsor, there's almost, I can't think of a single circumstance which would motivate me to say that you should go forward with the employer instead of the self-petition.
Got it. Okay. Thank you.
Thank you.
Thanks. We have next question. It's Sarah.
Hello, this is Sarah. Hi, Arianna. Thank you for the amazing information. So my question is, if I'm working, I have a master's degree and I'm working on OPT, but unfortunately not getting picked for H-1B given how things are going. How does EB2 NIW look for me particularly?
Yeah. So great question. I do a lot of these for people that are on OPT, CPT, and there's no problem with getting the petition approved from that position. But it becomes a little bit trickier when you're talking about maintaining status. So in case this is, I think probably there are some questions in here that kind of hinge on this as well, but just briefly, when you have your I-140 petition approved, nothing actually happens. You don't get any immediate benefit to your everyday life. So doesn't give you any lawful presence. It doesn't give you employment authorization. And then, of course, there are travel considerations that come in when you're talking about advancing into a change of status. So for people that are on OPT or CPT, the big issue is that you can get that NIW approved, no problem, no matter what status you're on at the time. But it's not going to help you have lawful presence once your OPT or CPT expires.
Awesome. I think I understand that. So I do have a few things in mind, in terms of solution, because as you said, let's say I'm on my OPT or my STEM OPT, and I do apply for EB2 NIW, and my I-140 gets approved. However, since you said there's no immediate benefit or any sort of visa to make me stay and keep working with my current employer, I've been working with my current employer to find ways to continue the job till the EB2 NIW is approved. And I would like to discuss all of these things in depth, but one-on-one. So how can I get in touch with you for a one-on-one consultation for the same?
Yep, Angel actually just shared my LinkedIn in the chat. So you guys can all feel free to find me there and schedule a consult with me through there. Just briefly, I'll say that what I often do for clients that are in this situation is we get the I-140 approved and then we go for an O-1 visa. So obviously not a long-term answer because it is a non-immigrant status, but it is pretty quickly obtainable if you're going to be eligible. Like premium processing is available and all of that. So there are options. It's just that you have to remember from the outset that you're going to have to do multiple immigration processes in order to stay in the US if you're in that boat already and you want to get the NIW green card.
Right.
Which it sounds like you understand.
Okay, yeah. I think I do have you on my LinkedIn, so I will definitely try to book a consultation on there. Thank you so much.
Perfect. Thank you.
Okay, before next question, Arianna, can I share your email address or just your LinkedIn?
Yeah. Here, okay. Let me type it in. There you
go. Okay.
Oops, no, I sent it to Adarsh. Sorry about that. There we go.
Okay, we have we have still a few minutes for more questions. So next one, it's gonna be Sunil, please.
Yeah, thank you so much. So my question is regarding the second prong. So for the second prong test, do we have to show the impact outside of our organization, or can we limit it to the work what we are doing in the current organization, like the something which is under the exceptional ability part of it? So just wanted to know about that.
Yeah, I think I'm answering your question here. Feel free to clarify if not. But if you recall, when I was talking about my recent approval for the specialized tech expert, many of the potential benefits that we discussed in the national interest argument were things that this client had never actually worked on, but knew that their expertise was capable of furthering. So it doesn't have to be only things that you have actually done at your company, but kind of the field in general in consideration of your level within that field or like how you're continuing to advance there. Does that answer your question?
No, basically, I'm trying to ask whether the work which I'm doing inside my organization and I'm not doing anything outside of the company. So is it like sufficient one to?
Yeah, it definitely can be. It all comes down to what it is that you've done, and again, how we can connect it to what you have achieved in the past and what you can achieve in the future. But there's no reason that you have to have like more academic achievements or things like that if you are making an impact in industry, right? In your job. It just depends on specifically what you've done.
Okay, sure. Thank you so much.
Okay, we have one more question from George, please.
Hi, Arianna. Thank you so much for this session. I have one question. I think I'm pretty similar to the tech person you mentioned earlier. So this is my story. I work for a SaaS company, but my work authorization is based on asylum pending, which has been pending for probably 7 years now.
Okay.
And I am also, I don't have a college degree, but I did take classes in software engineering. And then I am qualified for a master's program in tech without, So I'm trying to understand if this is a solution for me.
So there's, a couple of things are going on here. If you qualify for a master's like based on equivalent experience or I assume it's some kind of language like that, then yes, that master's would be as good as any other master's, right? As long as it is a certified school and all of that. So having a bachelor's would not be fatal to your eligibility. Not having a bachelor's would not be fatal to your eligibility if you have that master's. But then this is also one of those situations where you could use the list of criteria instead of having the academic background. And so it would be worth looking at your professional experience, your certifications, projects that you've worked on in your companies, what other people have to say about you, like all of that kind of stuff would be more important in your case. And then the second kind of nuance involved in your case is that there's a difference between work authorization and having lawful presence. And so asylum applicants are allowed to be here, but they are not maintaining lawful status. And so ultimately, you would not be able to adjust your status to a green card holder on the I-140, but you could still use the consular process once the NIW is approved and your priority date is current. So just a minor difference, you can't just do your green card application in the United States without a lawful status. But if you get your I-140 approved, you can still get your green card. It's just that you're going to have to do it through the consular process on an immigrant visa.
Right. By consular process, does it have to be in this US, or I have to leave and then come back in?
You have to leave and come back in, and it would be the Department of State that would be handling all of your your change to the status of a lawful permanent resident. So
Okay.
it's just this funny little thing that you can't use the USCIS application process. Instead, you've got to go through the Department of State.
Okay, and then my last question. So I'm not in product, I'm in biz dev. Is it a problem?
I mean, without knowing the details, I can't say. It's again, there should be no industries that can't theoretically fit into this NIW analysis, but certainly it's harder to document and explain your impact in certain sub-industries. So yeah, I would have to look at more than just this limited information to see if this is like a strong case or a case that's worth filing, but maybe not so strong, like that kind of analysis.
Okay, thank you. I'll definitely reach out to you on LinkedIn.
Great, thank you.
Okay, next question is Adarsh.
Yeah, hi, Arianna. Thanks for answering all these questions. My wife and I are currently considering going through the EB2 NIW process, but through our company law firms. Earlier, you mentioned that it's almost always better to do it separately, not through the company law firm. So why is that? And what do you meant by they will have a stake in the petition, and why is it better to do it separately?
So if for any of these classifications, you can have an employer sponsor you, but you can also do a self-petition. So we're talking about the sponsorship, not whose law firm it is, although it sounds like they would be a sponsoring employer if you're doing it through their law firm. The difference is that if it's a self-petition, the only thing that USCIS will ever consider in terms of finalizing your green card application someday will be like, have you done what you said you're going to do? So if your employer sponsors you and then your employer goes out of business, or your employer is forced to lay you off and they're no longer going to get the benefit of having you as an employee, then you're kind of out of luck with that approved petition. If you own it, the only thing that is going to matter for the life and the ultimate success of your green card application is what you do, not what happens with your employer.
So does that mean, like, if I were to leave this job, I wouldn't be able to use that approved EB2 NIW petition to adjust later? There
are steps that need to be taken to kind of move to a new employer, which it's not almost worth getting into when we're talking about something that's going to happen like in the future. And we're out of time, I think. But you don't have to worry about any of those considerations if you own your own petition. The only thing that you have to be aware of is that you should be considering your work in the area that you are basing your petition off of. But there's no specific relationship with any U.S. employer that would be needed.
Okay, so in that case, would I be should I pursue EB2 NIW separately as well as through my company? Is that recommended, or is that?
Yeah, I mean, look, it's a lengthy process. It's a costly process, no doubt about it. So to the extent that it's doable and it won't be a huge stress on the rest of your life, you would get like more bang for your buck, to say it that way.
Okay. All right. Thank you.
Okay. Lawyer Adriana, we just reached out like the hour. I mean, it's been really, really fast, but do you still have time to answer one or two more questions?
Yeah, I think I could do another 10 minutes.
Okay. So let's take probably two or three more questions. So next person in line is Shobit, please.
Hey, thanks a lot. Hey, Arianna. I have a technical question. I've pasted in the chat. It's about a comment that I saw in AAO decisions. And once you read it, I'll ask my question on how to interpret it.
Yeah, so if you just want to know like kind of my take on this passage,
Yeah, so
how to
is my
interpret it?
interpretation, is it the interpretation correct that they're almost saying that, okay, if you're STEM, then you are important, like the national importance piece, you don't have to worry about as much.
So as much would be the key language here. Yeah, I mean, they're saying basically that the STEM field should automatically kind of command more of their acknowledgement that what you do is in the national interest. And so it's not that you don't have to think about the rest of the application, but it's certainly a really good thing for people that are in STEM to see that they already are in a position that is not unknown to USCIS and is also something that they've affirmatively said, we love STEM people, like bring us all the STEM people, we'll give them green cards. But it's not that you don't have to worry about the rest of it.
No, not the rest of it, but definitely the NIW piece, the national importance piece, we don't have to worry about highlighting a lot more than having like a master's in STEM.
So the national interest is about all of the Donisar prongs, right?
Yeah.
So this is showing that you have national interest and substantial merit per Donisar. But there are other things that they consider that are about the national interest and about the overall picture, like the balancing factors of whether it really makes sense to let you waive everything.
Yeah, okay. Yeah, that was
so
my question.
You can think of it like you pass the first level of analysis for that first prong. But then they'll review everything again. Yeah.
Thank you.
Yeah, thank you.
Okay, we have now Nitin.
Yep, thank you. Hello, Arianna. Thanks for this informative session. So my question is like, what's the timeline looking at EB2 NIW and getting the green card compared to regular EB2 I-140 and then going to the green card? And that's the first question. And the next one is, can I know what's your experience handling the EB2 NIWs and what's the success rate your firm has? And what's the feedback you're gonna give if they don't have a strong case, if they can get back and get that moving forward?
Yeah, okay. So okay, first question.
The timeline.
The timeline. Okay. So between EB2 perm and EB2 NIW, the difference in timeline is going to be at the outset, where the perm process is taking a really long time. These days it takes like 2 years to finalize everything from the labor certification to the perm petition. You don't have to deal with that with the NIW, because with the NIW, it's obviously you're not looking for a labor certification or other government input before filing the petition. And so in that sense, it's maybe a year or two faster to getting your priority date. But then after that, that's kind of where the differences end, because they're still both EB2, both in the EB2 category. And so the priority date becoming current should be the same for both of them. Does that make sense?
Okay. Yeah, thanks. And can we, if I get the EB2 NIW, can I work and improve my case so that I can get to EB1A and get the green card faster?
Yes. So again, you would have an earlier priority date, and then you would move into a category where the backlog is not as significant, right? And so you would be able to cut off some time if you're able to qualify for that EB1A and have already had a priority date, from now. So instead of waiting and building your profile without getting any type of priority date, you would get the priority date and then continue to work on it as that time is passing.
Oh, perfect. Thank you.
Okay. Let's take the last question. Thank you so much for your participation. So I I know it's impossible to answer all the questions, so if you want to have a consultation with Arianna, we share the details, her contact information in the chat. So let's take the question of Kevin, please.
Thank you so much for the session. So I have a question. What's the difference between EB1 A and NIW in terms of research publications or like peer-reviewed journals? I know like EB1A is like really extreme, but how does it matter in terms of NIW?
Yeah, so with EB1A, the ultimate factor that will determine if you get it or not is how you compare to everybody in your field. And so that is why the number of citations is also is really important. Things like rankings, if that's available in your industry and all of that. With the NIW, you do not have to show that. You do not have to be extraordinary. You do not have to be one of the very top few in your field, which is the language for the EB1A. And so, yes, you would still want to include evidence of all of these things that you've done, but really having a couple of publications or citations, or like no one is going to be looking for 300 citations on an NIW petition. But every field is going to be different. If that's the only thing you have, then maybe you would want to make sure you have a bunch of them. If you've got a couple of other types of evidence of your success in your field, then it's probably not going to be that important to have quite so many. But again, there's no numerical minimum. There's really no hard and fast rules. It just depends.
Yeah, thank you so much.
Thank you.
Well, that's all that we have. Dr. Paul, please, you want to share like a last message?
Yes, oh my gosh, thank you so much, Angel and